your calls live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back tonight. It's Ask Us Anything night, so call in your questions. The 31 Law Call number 536-0077. Heath Brooks is with us tonight answering things, and we've got Donnie on the line with a question from Muscle Shoals. Hi, Donnie. Thanks for calling in. What's your question tonight?
Thank you. I got a question about land taxes. My mother, she's 97, in a nursing home, owns a house and still has to pay land taxes.
Okay.
I'm wondering, I'm totally disabled. Is it any way for me to take possession of the house or anything to keep from paying the land taxes?
Well, it depends upon your. There are some exemptions for land taxes that you can make, and it's going to be depending upon the county. And I guess you would be over in Colbert County or Lauderdale County, but it's going to be dependent upon. What specifically the county allows for exemptions. Sometimes the state will allow some certain exemptions. For instance, if you're a disabled veteran, sometimes you can get an exemption for being a disabled veteran if your mother transfers a property. You got to be careful though about, I don't know what kind of health your mother is in, but you got to be careful about transferring property if your mother is, if that's her only asset, because sometimes if she ends up going on Medicaid or something like that, that can get kind of weird. But yeah, that's one of those things you'd probably want to contact an estate lawyer that handles property issues and see if that could be viable for you. There are, and you can also sometimes have your, whatever the property taxes are on the property, sometimes you can petition the county to reevaluate the property to get the taxes a little lower as well.
This is kind of a follow-up to the Marie question at the top of the show. So we got in a text question. My mother had land before she was married. She passed with no will, just like we had with Marie's situation before. Is her husband entitled to get part of this land, or will it go to the kids?
Well, it depends upon what the assets of the estate are. There's a widow's share. If it is an intestate, meaning you don't have a will, there's a widow's share that goes to the spouse first. And then after that, I think it's the first $50,000 goes to the spouse, and then after that, $50,000 in cash or goods or real estate or personal property. Then half of the rest of the residual estate goes to the heirs, and the other half goes to the spouse. So the question is that maybe you get to keep the land all as the spouse, or maybe there is some of it that is split amongst the children. The big thing is look at your deed, because most of the time land does not pass, particularly if it's owned in a marriage, land does not pass with the estate. It passes outside of the estate with joint tenancy with the right of survivorship.
We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I bought a house at a sheriff's sale a few months ago, and I want to know if I can lawfully deed that house to someone else, even though the right of redemption is still outstanding. And if I do, and the former owner wants to redeem, do they redeem it from me, or do they redeem it to the person I conveyed the house to?
Interesting.
Well, you could always, I don't know about it, I don't think that you'd be able to deed it with a warranty deed, because you would have to have clear title at that point in time, and you're not going to be able to get a title insurance company that would provide you with title insurance for the purposes of a warranty deed. But you could quit claim whatever interest you may have in the property to someone else if you can find someone who would be willing to do that. And quit claim is just another way of transferring property, which is basically whatever interest you have. Of course, if I could quit claim Sharon here whatever interest I may have in some property over in Fulton County, Georgia, even if I didn't have any interest in it at all.
And I got nothing.
And you got a piece of paper.
I got 100%
so,
of nothing.
there is a way to deed whatever interest you may have. But in terms of the redemption, that I think that the redemption would have to go through whoever you quit claim whatever interest you may have.
Got a text question in. Okay, so he says, my buddy was driving a car back. A deer ran out in front of him and he got hurt. The customer, so I don't know if it's a repairman that's driving the vehicle, has insurance on the car. Who's going to be responsible? The customer gave him permission to drive the car. Okay, can you make sense out of it?
Well,
so driving a car and it's not your car and you hit a deer.
Yeah, I mean, that's first off, if you're driving a customer's car with that customer's permission, then you are a permissive driver of that vehicle. And that means that whatever coverage is on the car will transfer to you. You are actually becoming the insured. And so your option at that point in time is you have, if you hit a deer, we can't blame the deer. The deer is not going to be responsible. Deer doesn't have any insurance.
You're not going to collect.
They're not going to be able to collect. So, but what your buddy may be able to collect is if he was injured, he could get medical payments coverage, which is a type of health insurance coverage that sometimes people purchase through their car insurance company, and he may be entitled to get some medical bills paid back, and then also repairing the vehicle. So, there would be, if there was collision coverage on the vehicle or comprehensive coverage on the vehicle, then that could be utilized to repair for the vehicle, because that kind of coverage, it doesn't matter whether the deer is at fault or whether someone else is at fault, it will pay to have the vehicle repaired.
Okay, this may be kind of similar. Gabby wrote in an email question. She says, does car wreck insurance cover any damaged property that was inside the car?
The answer to that is yes, it can. When you get into a car wreck and you have, and this type of coverage can be depending upon who's at fault. If it's a person who hit you or caused the wreck, their insurance coverage can pay for property that's in the vehicle. And then if you have collision coverage, then there could be some coverage for you for some property that is in the vehicle. But generally what you want to look towards is if you are not at fault and someone else is at fault, anything that is lost in the vehicle for property, if your cell phone gets broken, if your car seat gets broken, those kinds of things are part of a claim that you can make to the person's insurance company who was responsible for the wreck, and we oftentimes we do that. That's one of those things that I'm cheap. I pick a penny up on tails.
Yeah,
sure. Not superstitious, and it's one of those things that you want to make sure you check all the boxes. I mean, the car seats are expensive now.
Everything in
car
there.
seats, cell phones.
Yes.
Back in the day, and I'm dating myself, CDs. CDs break. So,
every $10.
Yeah, that's right.
We got Mark on the line with a question from Fort Payne. Hi, Mark. Thanks for calling in. What's your question tonight?
My question is, we have a neighbor, and he lives down from us, and he asked if he could mow adjacent to his home on our side of the property for about 3 feet.
Okay.
To be even with his property, and we said yes last year, but could he claim that property by mowing that?
Gotcha.
Well, what you're talking about is a very, 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 very ancient legal principle called adverse possession. And the answer to that question is no. He likely can't claim that property just merely by mowing it. What he would have to do in that kind of scenario is he'd have to say, look, this is going to be my property now. He is actively taking over ownership of that property. He puts up a fence. He maintains it after that. You are excluded from the property and you just kind of let it happen for 10 years, then he may be entitled to the title of that property. But just letting the neighbor mow, 3 feet of the grass, that's not going to lead to an adverse possession situation.
We got in a text question. Recently had a family member that went into the funeral home and made all of her arrangements. I guess she paid for it and then she passed 2 weeks later. The funeral home's coming back and saying that they made a $1,600, $1,700 mistake. They're wanting more money. If she's already signed a contract and things with the funeral home, she's prepaid, can they hold the funeral home to that deal?
Yes, they can.
Okay, good.
Those are the four corners of a contract. I mean, once you have a contract with somebody, you made a mistake. I mean, that you got to make sure before you make a contract with somebody that it's right, and particularly when you're the business owner. I mean, if it's a situation where you're the less knowledgeable party, maybe you're the lady who passed away 2 weeks later, the less knowledgeable party, then you may have an argument to say, look, I didn't understand this. And there are some situations where that would apply. But if you're the business owner, you're in the business of selling funeral products, you're in the business of selling coffins, you're in the business of setting up funeral arrangements, and you're going to claim after somebody else passed away that the contract was wrong and you made the mistake, that's going to be a pretty tough sell.
Yeah.
And I would think that you'd have a pretty good legal argument that you don't owe that $1,650.
We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. Stay with us. (536-0770) or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does all sorts of family law. That's divorces, child custody sort of situations. If you want to reach her, she can be reached at 256-539-7337 or www.sharonfamilylaw.com.
So we got a text question in from Blake. Blake says, is it considered sexual assault if inappropriate text messages are sent after work when everybody's at home?
Generally, that would be considered sexual harassment, not sexual assault.
Okay.
Sexual assault requires a touching. So if you're sending inappropriate text messages on the phone, that's a situation where that could be considered sexual harassment.
I think they still get you in trouble at work, right?
It will definitely get you in
Sending
trouble
that to
at work.
coworkers, don't
It
do
is
that.
not something you should do, not advised, but likely would not be considered sexual assault.
Thanks for all your questions. We'll see you next week.